Good day, everyone. I'm Abigail France, and today I will be discussing the Chapter 7, Extinguishment of Sales, together with selection provisions under Article 1600 to 1604 of the Civil Code of the Philippines. This presentation focuses on how a contract of sale is terminated and how the law ensures that such termination is both valid and fair. To begin, a contract of sale may be extinguished through several means, such as the loss of the thing sold, as well as through redemption or rescission. This serves as the basic ways by which a contract of sale comes to an end. Article 1600 states that sales are extinguished by the same other causes as all other obligations by those stated in the preceding articles of this title and by conventional or legal redemption. This provision is important because it establishes that extinguishment is not limited to a single cause, but may arise from multiple legal grounds recognized by the law. Extinguishment of sale refers to the termination of the contract, wherein the rights and obligations of both the buyer and the seller are completely ended. Once extinguished, neither party can demand further performance because the contract no longer produces any legal effect. There are three types of extinguishment of sale, namely common cause, the special cause, and the extra special cause. These categories help us better understand how and why obligations are terminated. Common cause are those that apply to all types of obligations such as payment, loss of the thing, and condemnation. These are considered the most straightforward because they involve either the fulfillment or the natural termination of the obligation. For example, if a seller sells a laptop to a buyer for 50,000 pesos and the buyer pays the full amount while the seller delivers the laptop, then the obligation is extinguished because it has been properly performed. In another example, if a seller agrees to sell a specific car, but before delivery of the car it is destroyed by a typhoon without the seller's fault, the obligation is extinguished because the object of the sale no longer exists. Similarly, if a buyer still owes a remaining balance and the seller decides to forgive the debt, then the obligation is extinguished because the creditor has voluntarily waived the obligation. Special causes are those specifically recognized by law in relation to the contract of sale. This involves the legal remedies or conditions that affect the continuation of the contract. For instance, if a seller sells his land to a buyer but the buyer fails to pay despite demand, then the seller may rescind the contract. As a result, the contract is extinguished and both parties are required to return what they have received. Another example is when a contract includes a condition stating that the sale will be cancelled if a certain event does not occur. If that condition is not fulfilled, then such the buyer failing to secure a loan within a given period, then the sale is automatically extinguished. Extra special causes, on the other hand, includes conventional redemption and legal redemption, which are given special treatment under the law due to their unique nature and importance. Conventional redemption refers to the right of the seller to repurchase the property sold, provided that this right is expressly stated in the contract. Without such express stipulation, then the seller cannot exercise the right to redeem. For example, if a seller sells land with the condition that he may purchase it within 2 years, then the seller may regain ownership by returning the price and expenses within the agreed period. Legal redemption, on the other hand, is the right granted by the law to a certain persons to repurchase property in order to protect their interests, even if such right is not stated in the contract. For instance, if a co-owner sells his share of a property to a stranger, the other co-owners have the legal right to redeem that share in order to preserve ownership within the group. Under Article 1601, conventional redemption takes place when the seller reserves the right to repurchase the property subject to the condition agreed upon by the parties. This right must always be expressly stated in the contract. This means that the seller's right to redeem depends on a clear agreement and must strictly follow the terms provided in the contract. If the seller exercises this right within the agreed period, then the ownership of the property returns to the seller. Under Article 1602, which states a contract that appears to be a sale may actually be considered an equitable mortgage if it is intended to secure a loan. This highlights that not all contracts labeled as sales are truly sales. Indicators of an equitable mortgage include an unusually low price, the seller remaining in possession of the property, repeated extensions of the redemption period, and the seller continuing to pay the taxes. These factors show that the true intention of the parties may be to secure a loan rather than to transfer ownership. Article 1603 provides that in case of doubt, a contract that appears to be a sale with the right to purchase shall be presumed to be an equitable mortgage. This rule protects parties from unfair agreements by ensuring that doubtful transactions are interpreted in a way that reflects their true purpose rather than just their form. Finally, under Article 1604, the provisions on equitable mortgage apply even if the contract is labeled as an absolute sale. This emphasizes that the title of the contract does not control its nature and the true intention of the parties always prevails. To conclude, extinguishment of sale may arise from various causes, whether common cause, special, or excess special causes. However, the law consistently ensures fairness by focusing on the true intention of the parties and by protecting them from unjust arrangement. Having explained the concept of extinguishment of sales and its legal basis, I will now pass the discussion to Ms. Esiha, who will continue with the succeeding provisions.
Thank you, Ms. France. Let us now move on to Article 1605 of the Civil Code, which provides the remedy of reformation of instrument. Article 1605 states that in the cases referred to in Article 1602 and 1604, the apparent vendor may ask for the reformation of instrument. It is important to emphasize that what is being reformed here is not the contract itself, but only the written instrument. In other words, the parties already have a valid agreement, so there is already a meeting of the minds. However, the document does not properly express what they actually agreed upon. Thus, the mistake lies in the drafting of the instrument and not in the agreement. On the other hand, if there is no meeting of the minds, the proper remedy is not reformation, but annulment of the contract. Now, when can a party ask for reformation under 1605? In most cases, this happens in situations covered by Article 1602 and 1604, where a contract appears to be a sale, but in reality, it was intended to be a loan secured by a mortgage, also known as an equitable mortgage. In such cases, the apparent seller may go to court and request that the document be corrected so that it reflects the true agreement, which is a loan and not a sale. We will now proceed to Article 1606, which establishes the time limits for exercising the right of redemption. The provisions shown on the screen will be discussed and explained one by one as we proceed. To begin with, the right of redemption, or the right to repurchase, is not automatically granted by law. Rather, it exists only when the parties have expressly agreed upon it. Assuming that the right exists, the next question is, when can it be exercised? First, if there is no agreement granting the right, then there is no right of redemption at all. Second, if the contract grants the right of redemption but does not specify any period, then the law provides the answer. In this case, the seller has 4 years from the date of the contract to redeem the property. Third, if the parties agreed on a definite period, the seller must exercise the right within that given period. However, the period must not exceed 10 years, because if the agreed period goes beyond 10 years, the excess is not valid. This means that only the maximum of 10 years will be recognized by law. Lastly, if it appears that the parties intended to fix a period but failed to clearly specify it, then the law considers the redemption period to be 10 years. At this point, we now move to a more complex situation, when the nature of the contract is disputed in court. Because there are instances where one party claims that the transaction is an equitable mortgage, while the other is a pacto de retro sale. So in these cases, if the court finally decides that the contract is indeed a pacto de retro sale, the seller is given a grace period of 30 days to exercise the right of redemption. And that 30-day period is counted from the finality of the court's judgment. Following the discussion on Article 1606, we now move to Article 1607, which explains what happens after the seller fails to redeem the property within that period. So the provisions presented will be discussed further within our discussion. If the seller does not repurchase the property within the agreed time, the buyer's ownership becomes absolute and irrevocable. In other words, the seller completely loses the right to redeem. However, even if ownership has already become absolute, it does not automatically appear on the title. At this point, the law requires a judicial process. Specifically, the buyer must first obtain a court order before the consolidation of ownership can be recorded in the registry of deeds. The reason for this is to ensure due process, and the court must also verify the genuineness of the transaction, whether it is truly a sale or possibly an equitable mortgage. In relation to this, the buyer will execute an affidavit of consolidation of ownership stating that the seller failed to redeem within the allowed period and, as a result, the buyer's ownership has become absolute. Nevertheless, this affidavit alone is not enough. Therefore, the buyer must still file a case in court so that the seller can be notified and given the opportunity to be heard. It is important to emphasize that the hearing is not meant to determine ownership again, since ownership is already with the buyer. Rather, it is required for purposes of registration to ensure fairness and compliance with legal procedures. Next is Article 1608, which discusses the nature of the right of redemption. So, the right of redemption is considered a real right. This means that it is attached to the property itself and not just a personal agreement between the original parties. As a general rule, the seller or vendor a retro may exercise the right of redemption against any person who currently possesses the property, even if it has already been transferred by the buyer. In other words, the right follows the property. However, this rule is subject to an important limitation under the law on land registration. Specifically, for the right of redemption to bind third persons, it must be properly registered or annotated on the title. Therefore, if the seller truly intends to protect their rights to repurchase, they must ensure that this right is annotated on the buyer's title as stated in the deed of sale. And by doing so, any third person who later buys the property will be bound to respect that right, since it appears on the title. On the other hand, if the right of redemption is not annotated, the seller cannot enforce that right against an innocent third party who purchased the property in good faith. After discussing the nature of the right of redemption, we now move to Article 1609, which explains the rights acquired by the buyer in a sale with a right to repurchase. It is stated under this article that the vendee is subrogated to the vendor's rights and actions, meaning, in a sale with a right to repurchase, ownership is transferred to the buyer. In fact, the buyer becomes the owner of the property subject to a resolutory condition, which means that ownership may be revoked if the seller exercises the right to redeem. As a consequence, the buyer is subrogated to all the rights and actions of the seller. Simply put, the buyer steps into the shoes of the seller and acquires all the rights that the seller previously had over the property. However, this is subject to an important limitation. If the seller had no right to transfer ownership, then the buyer has also no right to acquire. Now, what are some examples of these rights transferred to the buyer? First, the right to mortgage the property. Since the buyer is now the owner, they may use the property as security. Second, the right to continue prescription. If the seller had already begun acquiring rights through possession over time, the buyer may continue that process. Third, the right to receive the fruits of the property, such as rent, produce, or income derived from it. To conclude, Article 1605 to 1609 outline the essential principles governing the exercise of the right to repurchase, the period and conditions for its enforcement, and the corresponding rights acquired by the buyer. So the next discussions will now proceed to the succeeding provisions to be discussed by Ms. Salumado.
Thank you, Isia. Now I will be discussing Article 1610, which deals with the special situation involving legal redemption, specifically when a creditor steps in to exercise the debtor's rights of redemption. Let's begin with the main idea. Article 1610 provides that if a seller who has the right to redeem a property fails to exercise that right, the creditor may exercise it on his behalf. This usually happens in situations where the seller sold property but retained the right to redeem it later, such as in a facto director sale or other forms of legal redemption. Now, why does the law allow this? The reason is to protect creditors. If a debtor ignores valuable rights like the right to redeem property, it could reduce the assets available to pay off debt. The law does not allow debtors to simply neglect such rights to the prejudice of their creditors. The principle is closely related to what we call actions of creditor, which allows creditors to exercise the rights of the debtor in order to protect their interests. However, there are specific conditions before creditor can exercise this right. First, the debtor must actually have a valid right of redemption. Second, the debtor must have failed or refused to exercise that right. And third, the creditor must act in behalf of the debtor, not for personal gain or ownership. Now, what happens after the creditor redeems the property? The effect is important because the property does not go directly to the creditor. Instead, it is returned to the debtor's patrimony or asset. After that, the creditor may then take legal steps such as attachment or levy to satisfy the debt. Next is Article 1611, which deals with partial redemption in a back to the sale. Let's begin with the main idea. Article 1611 provides that when an undivided immovable property is sold with a right of purchase, the buyer cannot be compelled to accept partial redemption. In simple terms, if the seller wants to redeem the property, the buyer has the right to insist that the redemption must cover the entire property, not just a portion of it. Now, why does the law impose this rule? The purpose is to protect the buyer. Without the rule, the buyer could be forced into an inconvenient situation, such as being placed in a co-ownership with the seller or other persons, or having the property divided or fragmented against their will. The buyer is allowed to refuse partial redemption. So essentially, the law allows the buyer to say, if you want to redeem the property, redeem it all, not just a part, or redeem all of it, not just a part. Let's now look at when this rule applies. There are three key conditions. First, the original sale must involve a single undivided immovable property. Second, the seller of or their successions attempts to redeem only a portion of the property. Then third, the buyer refuses to accept partial redemption. If all of these conditions are present, then the law will side with the buyer. Now, what is then the effect of the rule? The seller is left with only two options, and these are either the seller redeems the entire property or not redeem at all. The buyer cannot be forced again to accept a situation where only part of the property is returned. Next is Article 1612, which applies to a fact of the rental sale where there are multiple sellers or vendors. Let's start with the main idea. Article 1612 provides that when two or more persons jointly sell a property with a right of purchase, each seller has the right to redeem only his proportional share. At the same time, the buyer cannot be compelled to accept redemption of the entire property unless all the sellers act together. In simpler terms, if several people sold a property together, each one retains an individual right to get back only the portion that corresponds to them. They cannot need to act as a group in order to exercise that right. Now let's understand the implication of this rule. Unlike in some other provisions, the law here allows partial redemption, which means the buyer may be required to accept a situation where only part of the property is redeemed, while the rest remains with the buyer. As a result, the buyer may become a co-owner with one or more of the original sellers who chose to redeem their shares. Let's look at the effect of this rule. If only some of the sellers redeem their shares, the redeeming seller regains ownership of his portion only, while the buyer retains ownership of the remaining shares. As said before, this creates a situation of co-ownership between the buyer and the redeeming seller. At this point, it is important to distinguish Article 1612 from Article 1611. Under Article 1611, partial redemption is generally not allowed because it involves a single seller and an undivided property. And the law aims to protect the buyer from fragmentation. However, under Article 1612, partial redemption is allowed, precisely because there are multiple sellers, each with distinct shares and rights. So next is Article 1613, which continues the rules on fact of the rental sale, but this time it focuses on the rights of the buyer or vendee. So let's begin with the main rule. Article 1613 provides that when several persons are entitled to redeem a property, the buyer may require all of them to exercise the right of redemption at the same time. If they cannot agree, the buyer has the right to refuse redemption altogether. So now, what is the purpose of this rule? The law aims to protect the buyer from inconvenience and uncertainty. Without this rule, the buyer could be subjected to multiple redemptions at different times and complicated ownership arrangements with different parties. So Article 1613 gives the buyer control to avoid fragmented or piecemeal redemption. In simple terms, if multiple individuals such as co-owners or heirs has the right to redeem, the buyer can insist that all of you redeem together, or I will not allow redemption, since the buyer cannot be forced to accept a partial redemption. At this point, it is important to connect it with Article 1612. Under Article 1612, where there are multiple sellers, each one may redeem his proportional share independently. Here, Article 1613 acts a limitation to that rule. Even if the seller or their successions have separate rights, the buyer can override this by requiring them to redeem collectively. So let's look at when this rule applies. This rule operates when first there are multiple persons entitled to redeem, such as co-vendors or heirs. Second, they possess a valid right of redemption, and third, the buyer chooses to demand joint redemption. So what is the effect? If all the persons entitled to redeem agree and act together, redemption will proceed normally. However, if they fail to agree, the buyer may legally refuse any redemption at all. Lastly, Article 1614 deals with co-owners who sell their shares separately under a pacto de retro arrangement. Now let's begin with the main rule. Article 1614 provides that when co-owners sell their respective shares separately, each one may exercise the right of redemption only with respect to his own share. Consequently, no co-owner can redeem the share that were sold by others. In simpler terms, if several people co-own a property and each of them sells their portion through separate transactions with a right to repurchase, each seller retains an independent right of redemption. Now, what is the purpose of this rule? The law recognizes that in a co-ownership, each co-owner has a distinct and separate ownership interest. Since the sales are made independently, the law treats each transaction as separate and unrelated to the others. This avoids confusion and prevents one co-owner from interfering with the rights or transaction of another. So now let's look at the effect of this provision. If one co-owner redeems his share, he regains ownership only his portion, while the buyer continues to own the shares sold by the other co-owners. As a result, a co-ownership may arise between the buyer and the redeeming seller or redeeming co-owner. Please take note of the important limitation regarding co-ownership. A co-owner cannot redeem shares belonging to other co-owners. The right of redemption applies only to the specific portion that the co-owner originally sold. In simple terms, what you sold is what you can recover. No co-owner has the authority to redeem or reclaim shares sold by another. Before I end, let us briefly distinguish this from earlier provisions. Under Article 1612, the sale is joint and redemption may be proportional, but still arises from a single transaction. In contrast, under Article 1614, the sales are separate, or the right of redemption is strictly individual and limited to each seller's share. To conclude, Article 1614 emphasizes that in cases of separate sales by co-owners, each seller's right to redeem is confined solely to his own share, preserving the independence of each transaction. That ends my discussion, and thank you.
Thank you, Ms. Lumabao. Now let us move on to my part of the discussion. Article 1615, which discusses a situation where the buyer or vendee dies and leaves several heirs. The law answers the question, who should the seller approach if they want to redeem the property? Under this article, the seller cannot demand redemption of the entire property from all heirs as a group. Instead, the seller can only bring the action against each heir, according to their respective share, whether the property is still undivided or already partitioned. For example, if the buyer leaves the property to 4 children, each inheriting 1/4, the seller must deal with each heir based on their share. The seller cannot force only one heir to return the whole property. However, there is an exception. If the inheritance has already been divided and the entire property was awarded to one heir, then the seller may redeem the whole property from that heir. This rule ensures fairness by protecting both the seller's right of redemption and the heir's inheritance right. Now that we know who the seller can approach, the next question is what must the seller pay to redeem the property? This is explained in Article 1616. Article 1616 explains the payments required when the seller exercises the rights of repurchase. Redemption is not just about returning the original price. The law requires the seller to reimburse three things. First, the original price of the sale. Second, the expenses of the contract, such as taxes, registration fees, and notarial fees. Third, the necessary and useful expenses made on the property. Necessary expenses are repairs needed to preserve the properties, such as fixing a leaking roof. On the other hand, useful expenses are improvements that increase the property's value, like building a fence or making renovations. The reason for this rule is fairness. The buyer should not suffer a financial loss just because the seller decides to redeem the property. After discussing the required payments, the law also considers another factor, the fruits or crops on the property, which is explained in Article 1617. Article 1617 discusses the fruits or crops present on the property at the time of the sale or redemption. This rule is especially important for agricultural lands. There are two situations. First, if the fruits were already growing at the time of the sale and the buyer did not pay separately for them, then during redemption there will be no reimbursement or sharing. The seller simply recovers the land together with the fruits. Second, if no fruits existed at the time of the sale but fruits grew later, then the fruits must be prorated between the buyer and the seller. The buyer will receive a share based on the time they possessed the land during the last year counted from the sale anniversary. This rule ensures fairness since the buyer may have spent time and effort cultivating the land. Next, the law explains the condition of the property when it is returned to the seller, which is covered in Article 1618. Article 1618 explains the condition of property when it is recovered by the seller after redemption. The law states that the seller must receive the property free from any charges or encumbrances created by the buyer, such as mortgage or liens. In other words, the seller should recover the property with a clean title. However, the law also protects leases made in good faith. If the buyer rented the property honestly and according to local custom, the seller must respect the leases agreement. This rule balances the rights of the seller and the protection of good faith transaction. So far, we have discussed conventional redemption. Now let us move to Section 2, which talks about legal redemption. Under Article 1619, Article 1619 introduces legal redemption, which is a right granted directly by law. Unlike conventional redemption that comes from an agreement, legal redemption allows certain person to step into the position of the buyer by paying the same price and following the same terms of the transaction. This process is called subrogation. A common example involves co-owners. If one co-owner sells their share to an outsider, the remaining co-owners may exercise legal redemption by paying the buyer the same price. This allows them to keep the property within the group of co-owners and prevent unwanted third parties from entering the ownership. And that is all for my part. Thank you.
Thank you, Ms. Brabante, for that wonderful and concise explanation. Now, let's move on to Article 1620. So, what is Article 1620, you might say? Article 1620 simply means as the legal privilege given to a person who shares ownership of property to buy that portion sold by another co-owner before it goes fully to an outsider. So, how does Article 1620 works? When someone who jointly holds an item transfers their part to another person, even if that person is a close family member or a partner, the other holders have the chance to get that part instead. Take note that they must act within 30 days after receiving the formal word of transfer or the formal notice of the transfer. If the amount asked was way higher than the actual word, they only need to pay what is fair, or as we call it, the fair value of that item. Now that we know what is Article 1620 and how does Article 1620 works, let's proceed to Article 1621. So what is Article 1621? Article 1621 grants the owners of adjoining rural lands a right of legal redemption when a small piece of rural land is sold to a third person. So what does Article 1621 really means? It means that if several persons who jointly holds an item all want to get the part that was transferred, they can only claim it based on how much of the whole they already own. This ensures that the amount each one can pay matches their own or their existing part. Now let's proceed to Article 1622. Now, under Article 1622, it grants the owners of adjoining urban lands the right of preemption or purchasing before a sale, or redemption or repurchasing after a sale when a small, nearby speculative lot is sold. It applies when the land is too small for practical use, intended for speculations, and is sold at a reasonable price, typically within 30 days after receiving a written notice. Now, there are rules that says that you cannot use the chance to get back the part that was transferred if, number 1, the new owner is already someone who shares control of the item. Number 2, the item was given freely or without payment. Or 3, the item was passed down after someone has died or passed down. Take note that this only applies when the receiver is a total outsider from the original group. Now that we're done with Article 1622, it's time we proceed to Article 1623. So what is Article 1623? Article 1623 states that legal preemption or redemption, usually by co-owners, must be exercised within 30 days after receiving a written notice of a sale. This mandatory written notice from the vendor triggers a non-extendable period to protect co-owners. Now, what does Article 1623 means? It means that you have exactly 1 month after receiving a formal written message to make your move. Also, the paper that shows transfer cannot be used to put into official government records unless the person who sold it shows a proof that they told everyone who may have the right to buy in writing. Now that we're finished discussing or tackling each one of the articles on Chapter 7, it's time we proceed to Chapter 8, or the assignment of credit and other incorporeal rights. So, without further ado, let's tackle each articles inside this chapter, shall we? So, let's move on to Article 1624. So, what is Article 1624? Article 1624 states that the assignment of credit and other incorporeal rights is perfected in accordance to the provisions of Article 1475, or the contract of sale. It acts as a contract where a creditor, or as we call it, the assignor, transfers their right against a debtor to another party, or as we call it, the assignee. So what does it mean? It means that the moment this kind of transfer becomes valid and binding between the parties involved and follows the same rules that apply to regular sales, this means that the contract or the transfer is finalized as soon as both sides or both parties agree on what is being transferred and the terms involved on that transfer, without needing any extra formalities right away. Now that we're done with Article 1624, let's now proceed to Article 1625. So what is Article 1625? Article 1625 states that the assignment of credit, right, or action does not affect third persons unless it appears in a public instrument or is recorded in the registry of property if it involves real property. This ensures third-party notice of the transfer. So what does Article 1625 means? It means that passing on a debt, privilege, or legal claim does not matter to the people outside the agreement unless it appears or unless it is written in an official document. If the transfer involves real property like land or building, it must also be put into public records to be noticed or to be recognized by everyone else. Now that's all for Article 1625. I hope you've learned something valuable about this article. Now may I call Ms. Tenerife to further discuss the articles in Chapter 8, or the assignment of credit and other incorporeal rights.
Thank you, Mr. Sistosa. Good day, everyone. My name is Yorimer Tenerife. Today, I will be discussing some important civil law articles related to debt and credit assignment, along with examples to illustrate each article. Article 1626. Debtor repays the creditor before having knowledge of the assignment. This article states that if a debtor pays a creditor before being informed of an assignment of the credit, the payment is valid and binding upon the debtor. The debtor cannot be held liable for paying the original creditor without knowledge of the transfer. For example, suppose one owes Maria a debt. Before one learns that Maria has assigned her rights to collect the debt to Anna, one makes a payment directly to Maria. Since one paid without knowing about the assignment, his payment is valid and Anna cannot claim the debt for him. Article 1627. The assignment of creditor. This article explains that the assignment of a creditor's manner that is legally valid, often requiring a written agreement or specific formalities depending on the nature of the credit. For example, a company assigns its receivable for a client to a bank through a written agreement. This formal assignment allows the bank to collect the debt directly from the client, providing clarity and legal protection from the both parties. Next is Article 1628, responsibility of a vendor in good faith for the existence of legality of the credit. This article emphasizes that the vendor who sells a credit in good faith must ensure the credit exists and it is legal. If the credit turns out to be invalid or illegal, the vendor may be held responsible. For example, a seller sells a receivable to a buyer, believing it is legitimate, enforceable debt. Later, it is discovered that the debtor had already paid or the debt was illegal. The seller might be held responsible for misinterpreting the credit. Article 1629. Article 1629, duration of an agreement if the signer in good faith should have made himself responsible for the solvency of the debtor. This article provides that if the signer in good faith has guaranteed the debtor's solvency, the agreement's duration may be extended until the guarantee is fulfilled or the responsibility is released. For example, a creditor in good faith assigns a loan to a new creditor, but the original creditor had guaranteed the debtor's ability to pay. The responsibility continues until the guarantee is settled, even if the original agreement would normally end earlier. Lastly, Article 1630. Article 1630, inheritance sold without enumerating the thing of which it is composed. This article states that if an inheritance is sold without specifying the particular asset, the sale is valid but the buyer acquires the inheritance in its general state, including all its components. For example, a person sells an inheritance without listing specific properties. The buyer then owns all the states included in the state, such as land, jewelry, or other possession in their existing condition.
Thank you, Ms. Tenerife. Now let's discuss the articles 1631 to 1635. So this article reflects the principle of equity by ensuring that no party gains an unfair advantage in these transactions. So first, let's discuss the Article 1631, the lump sum sale and limited warranty. So this article applies when rights, rents, or products are sold for a lump sum. A lump sum means that a single price is guaranteed upon for the entire subject without assigning separate values to each component. In this type of sale, the vendor warrants only the legitimacy or existence of the whole. This means that the seller guarantees that the right exists and is valid, but does not guarantee the condition or completeness of each individual part. The warranty in this article is collective rather than distributed, meaning the buyer assumes the risk for defects in individual parts. However, the seller becomes liable if the defect results in eviction of either the entire subject or a portion of a greater value. In other words, liability only arises when the loss is substantial or affects the principal parts of the transaction. So this reflects the nature of the lump sum sales where the buyer accepts a degree of uncertainty. For us to understand better, let's have an example. For example, X sells his hereditary rights over an estate to Y for 2 million pesos. If it is later discovered that 60% of the estate does not actually belong to X, then X becomes liable because the loss affects the greater portion of what was sold. However, if only 5% of the estate is defective, X will not be liable. This is because defect is considered minor and does not affect the substantial value of the transaction. And this illustrates the law distinguished between significant and insignificant loss. Next, let's tackle Article 1632, which deals with fruits or benefits that the vendor has already received from the inheritance before the transfer is completed. As a general rule, a vendor must deliver or account for these fruits to the vendee unless there is a stipulation allowing the vendor to retain them. So this rule is based on two principles, accession and equity. So first, accession. Accession means that fruits follow ownership. So once ownership is transferred, the fruits should also belong to the new owner. While equity prevents unjust enrichment. The seller should not benefit from something that has already been transferred to another person. For example, A sells heredity rights over leased property. Before the transfer is complete, A collects 120,000 pesos in rent. So, since there is no agreement allowing A to keep the rent, A must deliver that 120,000 pesos to the buyer. This is because rent is considered a civil fruit that belongs to the owner of the property. Now let's move on to Article 1633. So this article provides that the vendee must reimburse the vendor for any payments made on debts, charges, or credits of the estate unless there is an agreement to the contrary. This ensures that obligations connected to the property are not unfairly transferred to one party alone. The principle behind this is simple. The person who receives the benefit must also bear the burden. If the vendor paid obligations that preserved or improved the estate, it would be unfair for the buyer to enjoy the property without reimbursing those expenses. For example, before selling hereditary rights, A pays 700,000 pesos consisting of estate tax, mortgage, and real property tax. After the sale, B must reimburse her 700,000 pesos because those payments cleared liabilities and preserved the values of the estate that B now owns. Now let's move on to Article 1634. Article 1634 applies when a credit is already in litigation and is assigned to another person. In this situation, the debtor is given the right to extinguish the obligation by reimbursing the assignee. So to extinguish the obligation, the debtor must pay the price paid by the assignee, the judicial costs incurred, and the interest from the date of payment. Importantly, the basis is the actual amount paid and not the face value of the debt. So the purpose of this rule is to prevent speculation. Without this protection, a person could buy a debt at low price and demand full payment for the debtor, resulting on unfair profit, of course. So the law protects the debtor from being exploited in that way. For example, A has a claim of 1 million pesos against C, which is under litigation. A sells this claim to B for 400,000 pesos. So instead of paying 1 million pesos, C can extinguish the obligation by paying B 400,000 pesos plus cost and interest. Once paid, the debt is fully extinguished. This prevents B from profiting unfairly from the transaction. And lastly, let us now tackle the Article 1635, which provide exceptions to Article 1634. So in these cases, the debtor cannot exercise the right to extinguish the obligation because the assignment is not considered speculative. So in here, we have 3 exceptions. The first one is the assignment to a co-heir or co-owner, which refers to a situation where the buyer already has a share or ownership interest in the same property or right. So, since the transferee is already part of the ownership, the assignment simply increases or consolidates their share. It does not introduce a stranger into the transaction, so there is no risk of speculation or unfair advantage. The second one is the assignment to a creditor in payment of a debt. So this happens when a debtor transfers a litigated credit to their creditor as a way of settling an existing obligation instead of paying cash. So the creditor is not only buying the credit to make a profit, but is merely recovering what is already owed. So because the transfer serves as a payment, it is considered legitimate and not speculative. And the third one is the assignment to the possessor of the property. So this applies when the litigated right is transferred to the person who is already in actual possession or control of the property involved. The law favors the situation where the ownership and possession are united because this reduces conflict and promotes stability. So since the possessor has already a factual connection to the property, the transfer is not seen as an attempt to profit from litigation. So in conclusion, Article 1631 to 1635 emphasizes fairness in the transfer of rights by properly allocating benefits, obligations, and risks between properties. So they ensure that no one gains an unjust advantage, especially in situations involving disputed rights. So overall, this provision reflects Civil Code's goal of balancing freedom of contract with equity and protection against abuse. So that is all for the presentation of Group 5. I hope you have learned a lot in our report. Thank you.